We are ready to start our meeting. Good morning. I am Gene Dinkins, and I will call this meeting. This is the January 13th, 2026 board meeting of the South Carolina State Board of Registration for Professional Engineers and Surveyors to order. Public notice of this meeting was properly posted at the South Carolina State Board of Registration for Professional Engineers and Surveyors Office, Synergy Business Park, King Street Building, and on the board website, and provided to all requesting persons, organizations, and news media in compliance with Section 30-4-80 of the South Carolina Freedom of Information Act. Members of the public who wish to attend may do so by live streaming appropriately. It is the policy of this state and purpose of this board to encourage the development of professional engineers and surveyors in this state and to promote the accountability for engineering and surveying practice in a global economy. The state recognizes the need for more qualified engineers and surveyors to support the local and global economy, and to that end encourages efforts to increase access to accredited education, examinations, and the experience necessary and appropriate to protect the health, safety, and welfare of South Carolina citizens and to support licensure as the basis of accountability. I'd like to welcome everybody to the meeting today, and board members Peter Strube, Angela Musselwhite, Kent Stair, Tim Rickborn, Jimmy Chow, Matt Kelly, Henry Dingle, and myself, and I'll let staff introduce themselves.
Eli Grote, Advice Counsel for the Board.
Chris Elliott, Office of Disciplinary Counsel.
Waddy Wharton, Lead Investigator, OIE.
Lenora Miles, Board Executive.
Kanisha Wilson, Program Coordinator.
Thank you. Next is a review and approval of our agenda. Motion to approve the agenda.
So moved.
Jenkins. It's my understanding from Mr. Grote that we're still waiting on the court reporter. So I'm going to ask that we move the application hearing number 10 and the disciplinary hearings after new business.
Let's move those until after the court reporter appears. That's a modification. Peter, is that okay?
That's fine. Second.
Motion and a second. All in favor indicate with an aye.
Aye.
Opposed? Okay, our agenda is approved. We have no excused absences today. I'd like a motion to approve our minutes from our last meeting, if you've had a chance to review those.
I move to approve the minutes.
Second.
A motion and a second by Mr. Dingle to approve the minutes. All in favor indicate with an aye.
Aye.
Opposed? Approve the minutes. Next, we'll move into item 8, our reports. The Office of Investigations and Enforcement report by Waddy Wharton, OIE Chief Investigator.
Yes, sir. Thank you very much. For the year 2025, we received a total of 94 complaints. Of those, one of them is still currently active. We have closed 49 of those. That is for your information.
Certainly glad to see that many of those closed. Good job. Thank you for that information. Any questions on the OIE? Item B is the Investigative Review Conference report, also by Mr. Wharton.
Yes, sir. On December 17th, we held an IRC with C.A. Shealy, Pat Gamble, Brian Bonds, and Kevin Crick via WebEx. We have a total of 9 cases submitted for your approval, 3 dismissals, 1 letter of caution, and 5 formal complaints.
I'll give everybody a minute to review this report. Questions on the report, or is there a motion on it?
I move that we approve the report as submitted.
Second.
Motion and a second to approve as submitted. All in favor indicate with an aye.
Aye.
Opposed? Okay, good, thank you. Next item is 8C, Office of Disciplinary Counsel Report.
Thank you, Mr. Chairman, members of the board. The Office of Disciplinary Counsel status report is in your materials. It requires no action by the board. We're at 33 open cases. We'll hear, actually 32. You dispensed with one of those a moment ago. We'll hear another one here after later in the meeting. I was a little surprised it was that low, frankly. As far as the older cases, I am efforting, pending some witness availability, having one of the older cases heard at the March meeting. Again, this requires no action by the board, is for your information purposes only.
Thank you, Mr. Elliott. Any questions about that report?
I have one question.
Sure.
In looking at your spreadsheet here,
Yes.
2024 M and N
Yes.
do not open case. Why are they still on here, though?
Well, that error, and I forgive me. Last week I was out a good bit ill, so I didn't pour over this like I usually do. That should ignore internet. They are cases that were not opened, and if you, my paralegal is doing a wonderful job, but she is new, and there's a lot of boxes you have to check to get this report, and we just didn't check a box.
That's fine. I just had not seen that before. And
Yeah,
was curious.
we normally omit those. Again, my fault. I'll take any confusion. I apologize for, but treat those as if they do not exist.
Any other questions? Thank you, Mr. Elliott, for your report. Item 8D is next on our agenda. That's the administrative and financial reports by Lenore Addison Miles. Lenore?
The licensing statistics report has been provided in your meeting materials, and it contains a breakdown of the licensees in-state and out-of-state that are active with an expiration date of June 30th, 2026, and a reminder that this is a renewal year. We're in the process of working on the renewal information now. As of July the 7th, there were 21,454 engineers, 902 surveyors, and 100 dual licensees current through 2026. There were 3,916 firms and 1,364 branch offices that are active through March 31st, 2027. The NCEES CBT summary for the January through March testing window shows a total of 259 fundamentals of engineering, 15 fundamentals of surveying, 95 PE, and 3 PS, and 2 structural exams, and those totals include scheduled and delivered exams. We've received 3,054 early PE exam applications, and 2,041 have passed the exam. We've also received 48 early PS applications with 32 passing. Your materials also contain the information regarding the total number of the in-state and out-of-state early PE and PS exam candidates by year. The November cash balance was $4,653,000. $640,481.99, and the Education and Research Fund was $733,774.59. Effective January 1st, your mileage rate increased to 72.5 cents per mile. Thank you.
Thank you, Lenora. Any questions of her report? No questions. I would like to point out, I'm very pleased to see in the NCS CBT summary, always watching closely the number of surveyor candidates out there, and for January through March, for us to have 15 fundamentals of surveying scheduled in a 3-month period is remarkable. Those are FS. Those are not state-specific, coming in from another state. Those are new people trying to get, not trying, the pipeline to get licensed as a surveyor. So point that out to SCSPLS that is a very good positive sign. Allison? Okay. Next item on the agenda is item 9, a legislative update, and it's Senate Bill S-706, the title Engineering Advancement and Public Safety Act. I asked Adam Jones to come and make a presentation about that proposed legislation to the board. So at this time, Adam, I'll turn it over to you.
Oh, sorry. Thank you, and thanks for putting me up on the agenda. Today is the first day of session, and I'm hoping to meet with Senator Rice, who introduced 706. I'm going to go briefly over what's added to this. This is in the Practice Act, but I think Lenora did give you a copy of this. Anything underlined is new language, but there's several alarming things, the first being the erosion of the education thing. But the first part is, and some of these are questions to the board, the first addition is a person must pass a public safety and professional ethics examination approved by the board. Is this something that exists already, or are y'all going to have to establish this if this bill passed? Okay. Okay.
No, we do not have one.
All this, to help me with Senator Rice, who did this, and I'll talk about how we're going to go at this after this. The second new portion of the Practice Act would be, in lieu of a degree requirements of the subsection, applicant may be eligible upon presenting evidence satisfactory to the board the applicant has completed 8 years of progressive engineering experience following graduation of high school and passing the NCEES fundamental engineering examination. In preparation of this, I did reach out to, I can't remember his exact title, but Josh Twitty, who I'm just going to say lobbyist for NCEES. I know that's not his actual title, but just asking if you could sit for the FE exam without graduating college. And he said that the outline says that you have to be within, I think, 2 semesters of graduating college, but to sit for the FE, but it does also stipulate that each licensing board has, autonomy on that to allow people to sit. But he said it would be very hard, and he also, just for, as we defend this to the legislature, what the pass rate they think would be, which is very, very low. Other addition is successful completion of the FE exam and upon completion of a minimum of 12 years experience engineering experience, followed by A, supervision of a licensed engineer of character satisfactory to the board, and B, indication that the applicant is competent to practice engineering and passing NCEES's examinations acquired by the board. This doesn't lay out that it's a PE. So the way I read this says that you can have this experience after high school and just sit for the FE and you'll be able to get the PE, though it does still have like a portfolio review, but they'd be able to come in front of you after this. It also, it kind of contradicts itself in the fact that it says 8 years after high school and then another 12 years followed by that. So the way I read this, and I'm not sure if this is what they meant, that'd be a total of 20 years experience to get that. But even then, that's not part of the 3-legged stool. So the organizations, ACC South Carolina, SCSPE does oppose this in any shape or form. the portion where I did say that there would be a portfolio review, they add, with respect to progressive engineering experience, one, evaluating the work experience required by the board shall consider A, total experience record, and B, progressive nature of the record. Two, not less than one half of the required engineering experience must be A, a professional grade and character, or B, performed under responsible charge of a licensed professional engineer. So the way I read this, that would be contradictory to what's now, which is 4 years underneath a PE. That would only be half the experience would have to be directly under the supervision of a PE. Another addition, for the purposes of this chapter, the term progressive engineering experience means during the period of time in which the applicant has made practical use of the acquired knowledge, he has shown continuous improvement, growth, and development in the use of knowledge as revealed in the complexity and technical detail of the work product on record. The applicant must demonstrate the greater individual responsibility for the work product has been continuously assumed over the period of time. In calculation of progressive engineering experience prior to graduation may not be considered except that an ABET accredited engineering cooperative experience may be considered as a maximum allowable credit for a year. Experience obtained in a foreign country unless performed under the direct supervision of a professional engineer licensed with a member of NCWS may not be considered. There's a lot of poor writing in here, but another thing just to point out as we defend this, NCWS is not the licensing group. They don't give licenses, they just give exams. In evaluation of progressive engineering experience, the board may give the following maximum credit for experience of the following areas of work: graduate schooling of research and approved engineering curriculum resulting in award an advanced engineering degree with maximum allowance of 2 years of such experience. B, progressive land surveying with maximum allowance of 2 years of such experience. And C, teaching of engineering subjects at university level and approval of engineering curriculum within maximum allowance of 2 years of such experience. This portion alarms me just as much as the high school thing, because this is altering what is already existing. And the way I read this says that surveying experience would give you experience as a PE, as well as your grad school. I know that does alleviate some of the experience, but it also affects that. So in total, this bill is, besides poorly written, very, not good for what we are here to do, or what we do currently. In preparation for this, this was pre-filed. Lots of times, people pre-file bills to show a constituent that they are trying to act on something. I called Senator Rice, who is the sponsor of this bill, as soon as I read this to ask about where this is coming from. He said that he has an individual in his district that can't get licensed. He didn't specify why, and that was why he did this. But he's also a contractor, and he said, I'm paraphrasing here, that I get plans all the time where when you put a hammer to nail, they don't actually work. So I could not get a feel for if this is something where he just pre-filed this to subdue a constituent, or if he actually means to push this. And that's why I asked to be early on the agenda. I plan to meet with him soon. I'm going to go straight to his office and sit there until he gets here today. I've talked with Virginia, with LLR, as well as Josh at NCWS, just so we're all kind of reading from the same sheet of music on how we're going to approach this. Like I said, ACEC and SCSBE are opposed to this and plan to fight it in every way. But things that I do want to learn is I've talked to some people who are in Rice's district and believe that this may be a case of a person who has an engineering and technician degree that can't get licensed. That's just something to let y'all know. I don't know. Right now, I wouldn't offer any kind of compromise at all, but if he came back saying, well, y'all sunset this in 2020, would y'all be willing to consider undoing that sunset that had a path to licensure for technicians? Is something we'd have to come back and discuss. If that is the case, if this is truly someone who has just graduated high school and worked for under an engineer for 20 years and is looking to get licensed, obviously that's something else that we're going to have to fight. I have alerted our membership, and several people have reached out to him already. I asked ACEC and SCSP's members not to go too crazy on him yet, just so I can get more of a litmus test to see if this is something he's actually going to push. I don't want to make him mad enough to get aggressive about this.
Thank you for that information, Adam. Questions, comments?
So, I mean, my first comment is, you know, the title of this act is an Engineering Advancement and Public Safety Act. And everything that's described in here goes against advancing engineering and against advancing public safety. You know, I've gone back and looked at some NCS information. First, some information on NCS's website in 2023. Only 7 of 55 jurisdictions have a pathway to licensure with a high school degree, and most of those are in the sunset stages at this point in time. South Carolina sunset it in 1977 with the passage of statute revisions that took place in 1972. I fail to see how this advances the profession. As far as toward the end of what you had presented, I guess the last page, page 5, item number 4A, experience prior to graduation may not be considered except that ABET accredited engineering cooperative experience may be considered. ABET does not accredit engineering cooperative experience. Again, poorly written bill. Then the last item, 5C, where it comes to subjects at the university level, in an approved engineering curriculum with a maximum allowance of 2 years of such experience. It's my opinion that greatly will discourage faculty licensure by only granting the
Thanks, Tim. I'll take this with all my other stuff to take to him.
It also seems that if we've got a contractor who receives plans he thinks are not up to snuff, lowering the standards is not going to help that.
I would say you should be encouraged to file a complaint if they don't meet the standard.
I have to give him credit for thinking more about his constituents than about his profession and his work, because if he truly is interested in producing a good product and he's burdened by the fact that he's getting plans that he doesn't think you doesn't make work, he would want.
Any other comments from the board? In my looking at it, I see it as being something that's totally unmanageable from the board perspective. The board is set up to review each and every candidate for licensure like this would require. This basically guts the three-legged stool by allowing someone to potentially get licensed with just an FE exam without education. You just have one leg, not two, not three. And that one leg is questionable when you get experience for, survey work, co-op work. It just, as Tim says, it's, the name is a total misnomer here. Microphone, it's not picking you up there.
Is that? I think about it more, I'm celebrating my first anniversary here on the board, and I'm sort of learning what my position is and is not. And what I am not is an engineer or a land surveyor like the rest of all these other people. I'm just a member of the public. And my role here, I think, in addition to their having the same role, is to protect the health, safety, and welfare of the public. And on behalf of the public, I would like to say this bill does not do that. 35 years in the world of dealing with engineers and surveyors and architects and public safety. And I can tell you this bill here, if he's interested in the public, this is contrary to the public's interest.
Any other comments? I know it's kind of, in the past, this board has taken positions on legislative matters. I've been told that it's probably, we could vote on this as a board, or we could not vote on it as a board. I would like to send a strong message. I think what I'm hearing unanimously from everyone that's spoken up is that the board has extreme grave concerns about this bill, and there would be absolutely no support for this bill. In fact, opposition from the board if this, in fact, moves forward. Is that a true statement? Okay, Adam, have we given you enough ammunition to go back?
Sir. Yes, sir. And thank you all again for putting me up here. I do want to extend an invitation to all of you for tomorrow's night legislative reception. So you might be able to speak to him in person. So that's from 5 to 7 at Burt Foreman Law Firm at 1221 Main Street.
Thank you for that. Since we do not have a court reporter yet, we're going to skip over item 10, an application hearing, and move on to item 11, funding request, SCS PLS Convention Technical Conference. Allison?
Morning. Sorry, I have a little bit of probably what Lenora has. It's awful. I feel it for you, but I'm here today to talk to y'all about the $55,000 request that I made this year. That is more than I've ever done. But the reason why we, as a board, decided to up it, I had planned on doing an extra $5,000. I knew that I'd been told that our speakers last year were not great. And so to get better speakers, unfortunately, we have to pay for them. So we are paying for speakers this year. So I'd planned on asking for an additional $5,000, so for $50,000. But you'll see I bumped it to $55,000 this year. And kind of further to what y'all were reporting on our increased numbers of people taking the FS, we are working really hard with potential surveyors. Our Young Surveyors Network has done an incredible job. But with them doing that, we are doing something this year. For 2 hours, we're having a panel discussion for people who are interested in becoming licensed as a surveyor. So for 2 hours, we're going to have a panel to talk about how to get licensed, how to study, where the places to go. We have 4 people that are talking on it. And their idea, and the young surveyors, and we support this, is to take them and kind of form that networking that is so important and take them to bowling, to go bowling for a couple hours and have some food, just so that we can form those bonds. We're hoping some licensed surveyors will go as well. It's not guaranteed, but because they're younger and a lot of them have smaller families, we're trying to keep the price down. So that's why I added that $5,000. So it is a big request, I know that. It's $55,000, but understand that the 50 that we were asking for is because, I say this every year, AV and food go up every year, unfortunately. This year we are paying for some speakers to come in. We have Wendy Lathrop. She's coming in to speak for 2 full days. She's kind of pricey, but we have her coming in. And then we have Diamondback out of Texas, and we have somebody out of North Carolina. So we are paying more speakers, and we're going to have to pay for their hotel rooms and their their stay. So that's why we did go from 45 to 50, and then the 50 to 55 is to encourage these younger surveyors. So I'm open for any questions. You should have a spreadsheet. If not, let me know, kind of detailing all the costs that we're foreseeing. AV, you'll see is up to 18.5, and that's just with me just automatically quoting what we had last year. So there's a chance, I'm fighting literally with them right now. Same with our food. I feel like it'll be pretty comparable. Last year was a little more expensive food-wise, and it has gone up again, but I think that 5,000 is going to kind of cover it. But I'm open to any questions that you might have. And I did put it at the bottom. You'd see if we didn't get the grant per person, it would be $685 a person to attend. But with the grant, it would be about $410 per person, and we charge $399.
What was your attendance last year?
It was, last year scared me. We ended up over 300. I think it was around 310. Our registration is pretty good this year. We've got a lot of young surveyors registered already. But our big, if y'all know anything about me, I freak out so easy over these things. But most registrations come in the last month before the event. So, we had DOT do their big registration yesterday. So we're pretty par for the course. We should have between 300 and 350 people.
Have you sent out the registration information yet?
Yes, it goes out every Friday. It's on all of our socials. It has all their speakers. All of our speakers for once are filled except for 2 hours. And I've found 2 people that I've talked to this week about getting that filled. So we have 3 tracks this year instead of 2. I've been taking feedback, like what people want, what they don't want. So we've worked really hard to make this what it was before COVID. COVID kicked our rear with this conference. So we're trying to get it back to what it was before COVID.
Yes, I missed it, so I need to go and look at your.
I'll send it to you. I can send it when you get back.
That's why I motioned you. I wanted to see you before you left because I need to be on your list too because I don't have it.
I don't think.
Yeah, I'll send it out. It goes out every Friday. I kind of have it towards the bottom, but if y'all have social media, we're just blasting the bejesus out of it. So we're trying to get people. We're trying to get more people. We're really, not that we're not focusing on our current licensed surveyors. That's why we had it out before December 1st. I heard that last year. We got out the speakers too late because speakers were off. Trying to get speakers last year was terrible. So this year we had it out. I said December 1st. We made it out on the December 3rd. But you can find it on our website. I can send it to all y'all. I thought I put that in the email, but if it didn't, I'll send that to you.
Allison, did you do the Young Surveyor event last year? And do you think that contributed to the conference in general contributed to the increase? That's
I don't know. I hope so. Last year was the first time we had a Young Surveyors meeting in person. Before that, they'd been doing it all virtually. So at the conference last year, we did have a meeting where anybody could come. You could be the Young Surveyor or you could be the licensed surveyor, trying to make those connections. So I know he's not here. Y'all might not know him. Ben Allen has done an incredible job. He just got licensed, by the way. Yay. But he has done an incredible job reaching out to these kids. They're not kids. They're 20s, 30s, 40s. But they've done a great job. He's done a great job. We've started a new thing, too. When they get licensed, if we find out about it, I immediately put them in touch with Ben. So we're trying to really foster that relationship to get, because I do feel like our numbers are going back up. We've worked really hard for years to get our numbers back up. So I think it's finally, all this work is finally starting to trickle up, but I can't take credit for it. But I do think on the whole, surveying has become a more lucrative job. I get calls all the time about, how do I get licensed? So we're trying. We're definitely trying.
One day?
2 days.
2 days,
So it's all
okay.
day Friday, all day Thursday, all day Friday. It's a lot of classes in 2 days. It's 15 hours.
Mr. Chairman, it's a big number. Being an engineer, you do the math. And this is if you got 250 at 15 PDHs, this is an investment of less than $15 per PDH, which I think is pretty low, and I think something that, what we can do for the surveying industry, I think supporting that at that kind of a cost, even though that from first blush, 55,000 seems to be a big number. But when you spread it out over 250 people and that number of potential PDHs, I think it's well worth the investment.
I will say this is a very well-run conference, and Alice and her group put a lot of work into it. And if you look at our mandate with our Educational Research Fund, this fits that role exactly. You know, we're promoting licensure here, and this is you know, this is what it's about. And you know, we've stuck with it and paid for it for a lot of years. And I think, as Allison says, it's finally turning around. I mean, you saw in our reports earlier today, we have 15 FS exams for the first 3 months. And, you know, that's phenomenal. And conferences like this are very key to getting those numbers up.
Allison, I want to echo what most everybody said here today. I mean, you know, we this conference several times, and even before I was on this board, I would hear people ask me all the time, what is the board doing for licensing surveyors? And, you know, why do they make it harder and harder? It seems like was one of the responses I always got, and I always said, well, what are you doing? Have you tried to encourage one of your workers to be licensed? And I really want to pat this society on the back for really taking a big step forward and doing what you're. Thank you so very much for the profession, because like anything else, we want to leave it better than we found it.
Any motion concerning this funding request?
Make a motion to approve the funding request.
Second.
A motion and a second to approve it. All in favor indicate with an aye.
Aye.
Opposed? You got your money.
Thank you, thank you. I hope to see y'all there. Also, I can't remember if I've even asked yet, but we are going to ask y'all to speak that first hour again. I think that's important. I'll send y'all an email. I put y'all down on the schedule. Thanks, y'all.
We're already on the schedule?
Yes. Thanks, y'all.
Thank you.
She's referring to Henry and I for several years now have been the kickoff speakers of the conference. And in the past, we've had other board members show up, Lenora show up. Would like to invite and encourage anyone that's available to come and be seen there off of this. I think it's well worth your time. Allison, is that okay? And Jimmy was there last year or year before, or?
Year before, yeah.
Yeah, but anyone that can make it, please come. Lenore?
Both of y'all came, didn't you? Good.
Got that, yeah, good. Kenesha, please come also. Okay, that's item 11. 12 is a disciplinary hearing, which we will also postpone until we get a court reporter. So moving into item 13, action items from our November 18th board meeting. Someone tell me what page these are on.
206.
Let's see. 1 done, 2 done, 3 done. West, is that taken care of? Item. the next three. Eli, Ryan,
Those orders are still pending. I'll make a priority to get them finished up.
you, construction experience, has your name beside it. Can you tell us anything about that?
Yeah, nothing more to report at this time.
Surveyor education evaluations. We discussed that. Is that now been implemented satisfactorily, Lenore?
Now, that involved two different items. This one on the report is the education evaluations where we discussed doing a pre-approval type thing. We'll get an update on that in March. Now, as for the review, that we wanted to change the process, if someone was not approved, that it be sent to a member, we started doing that because we've already sent some to Mr. Kelly.
Good. PDH credit for attending board meetings. Anything new?
I plan to provide an update on March. I had blocked off last week to do some work on that to get you an update, but unfortunately I had an unexpected passing in my family that put me out of work. So I plan to give you an update on that in March, if that's okay.
That'll be fine. Thank you, Eli. 2026 Southern Zone funded delegates to the zone meeting. I guess we're talking about zone meeting there, correct?
If the funded delegates have been submitted to NCEES, so those individuals will be getting an email. And the travel request for funding from LLR, that has been sent to management, so hopefully we'll have a response within the next week.
All right. That concludes then, unless anyone has any questions, concludes item 13.
Mr. Chairman, if we get an update on those that are being funded by LLR for the Southern Zone, can you let us know when?
Yes. The request is being reviewed by management. Hopefully, we'll get a response next week or so. Okay, and I'll send you an email and let you know. Okay?
Thank you.
I do hope we can have a very good board representation at that zone meeting because that is Jimmy meeting as zone VP. So we want to make sure that he has a lot of people there to support him.
I appreciate it, just don't pull on me.
Not that you'll need it, but we'll be there to ask you hard questions.
Bring your credit card, Jimmy, for lunch and dinner.
That's an easy part, I can do that.
And a few extra nights of stay, too. Yeah. Okay. Item 14. To give a little background here. Several years ago, I guess it's been probably 3, 4, 5 years ago, the board came up, maybe longer than that, as successor engineer surveyor guidelines. It was presented to the board at that time that if a licensee, something happened to that licensee and he or she were in the middle of a project and due to a hardship case, somebody had to take over the work that was done by that engineer or surveyor. It did not seem fair that, say, if someone's 90% finished in the design of work, that that person died or retired or was incapacitated in some way, that the work had to totally start all over again, both on the engineering and survey. The board came up with some guidelines that were intended to unexpected hardship on an engineer or surveyor. And I think it's been good. It spells out that someone else can come in and take over that work, sign and seal it, but they have to be 100% responsible for that particular work. I asked this to be placed on the agenda because Eli was contacted with some questions about the successor policy, and it appeared to me that the person asking these questions, they certainly were valid questions, but it was more of a convenience rather than a necessity, the situations that they were describing. So I wanted to bring it in front of the board, and you can see the questions on the right side of the email here, and this is on page 208, and see what the board thought if we need to potentially make some modifications or revisions to our successor policy. So with that, I'll open it up for discussion.
Again, I guess being new, is a guideline a law, or is it, well, what's the I mean, what's the lawyer, I'll ask the lawyer here the question, what's the legal status?
Guideline is just generally an attempt to clarify a policy, but it's not a regulation or a statute, so it's not necessarily a binding norm, if you will.
It was really something we came up with, again, to alleviate any hardships that were unavoidable on behalf of the licensee. And with the hope that if we came up with some guidelines, at least we could be uniform in our application of our decision.
It seems like the questions are somewhat hypothetical, so they're not like complete questions, and it's like, it's almost a case-by-case basis on some of this that would rely on, specifics of a project, not that we're evaluating things on a case-by-case basis, but how often does this happen? And I know personally, in my practice, I would have pretty much redone everything. Now, maybe part of that's influenced by the fact that I was a geotechnical engineer, which is particularly fuzzy sometimes, but I don't know, are we spinning our wheels trying to address a bunch of hypothetical questions that might not ever be real?
Well, maybe. I don't know, but, and perhaps I was reading too much into the questions, but to me, it came to mind that, well, perhaps someone finished a design 90%, and then the employer just wanted to take him off of it and have him go do something else, make someone else come along and sign it. And it, maybe it could potentially lead to just rubber stamping in some cases that, if you take on a job, unless something that you can't control comes along, you should finish it. And here, it looked like it opened the door up more for, here I did most of the work. I'm done with it now. You sign it. I'm going on and do something else. And that first person either licensed or not licensed or whatever. Rather than answer the questions, it began to bother me, that we were open door here for some unintended consequences.
This is just my first look at this the thing. I looked at it preparation for this, but I really haven't otherwise studied it. It does seem that when you say a licensee can no longer provide services such as, and then you list death, retirement, disability, those three things seem to be similar because that's something that the engineer cannot or the surveyor cannot then continue. But contract termination seems to be a different, that, if I'm an owner and want to do what you want to just suggested, we just have a rubber stamp. It seems the way to do it is let the first person take it 90% and then terminate the contract and say it's now terminated. I need a rubber stamp. Can you give it to me? And the person says yes, and here's my reasoning, because the person can no longer provide the service because they've been terminated. I mean, I just looking at the underlying thing more than the questions at the moment.
The et cetera bothered me also. Et cetera could be because, your boss put you on another job then. He maybe didn't have to, but he,
Once you open up the world by contract termination, which can mean just about anything, and when you add then et cetera onto that, it really does explode it, yeah.
those were my thoughts exactly, and I thought we wanted to tweak this a little bit and add some language intended for situations that were, unavoidable and not per convenience, and maybe make reference to some of our language in our statutes or regulations about being responsible in charge of a project.
This also, as I look at it, there strike me as at least four potential interested parties here. One is the owner who has paid for it up to the point of the departure. The next is the original licensee who has done something. And the third one, which is the person licensed taking it over. And then there's fourth, the public, who is impacted by whatever all of those three combined to do. And so I guess the question is, whose interest are we looking out for here? And, owner and a death occurs, I would hate to say, gosh, do I have to now take that 90% of what I've paid, flush it down the commode and pay somebody else 100%? That's not fair to me. If I'm the person taking over, I say, I'm going to accept all the responsibility but only get 10% of the pay. That doesn't seem like that's good for me. The person who can't do it doesn't really, if they really can't do it, as opposed to just they were terminated for whatever reason to not do it. And then, of course, the public is, if you get in the end the same positive result you would have gotten in the beginning had the first person taken it through completion, done a decent job, and accepted the responsibility, then that's okay. But if what you get as the public is a short end of the stick because the process was compromised by a changing of the horses in the middle of the stream, then that's not good for the public. So I guess the question is, whose interest are we looking out here for, and how do you best resolve all of them to the most satisfactory? Because obviously if somebody dies, that's simple. They're not going to finish the design. Retirement, I'm trying to retire, and some folks have had more success at it than I have. But, if you're disabled, you can't do it. But, termination is a wink, a grin, a frown, is all kinds of terminations, and that can be manipulated. And as you say, et cetera, pretty much means once you've added contract termination, anything anybody wants to say it means. So anyway, more thoughts than decisions with or questions than answers.
I think at the end of the day, it also comes down to just the responsibility and the liability associated with it. Whoever is putting their signature and stamp on that particular set of drawings by statute is basically saying, requirements that it should. So, I think Ken brings up some good points. Yes, I think we've always been bothered by the et cetera. Maybe it can be looked at a little bit more, but If I just read the question that was asked of question, I think the answer to that is yes. Somebody else started the work, never stamped it, and then somebody else takes it over and stamps it. Are they responsible for it? Yes, they're responsible for the whole thing.
Question about that, if you put your seal on it, you own the farm.
Yep.
Sometime back when I was in practice, we had a surveyor that signed a plat on a very large piece of property. There was a farmer, and the farmer passed away, and the surveyor moved away. So the wife needed to get the plat recorded so she could sell the property. And I called a member of this board that's not on this board anymore, said, what do I do about this? She doesn't want to pay another $45,000 because I can't sign this plat. And he said, well, you have to put a note on the plat that you're signing as a member of your firm, and you have to stamp it and put your signature on it. I have no knowledge of it. I didn't work on it. He says, the note will cover that. So what do we do in that case?
Prefer to be the plaintiff's lawyer in that case than the defendant's lawyer, I think.
Yeah, well, that's not a good answer.
My preference in the situation, I think, as I understand. I mean,
But see, it was only, had been only done a year or so before.
did the original surveyor sign it and seal it, or just sign it, or what?
He did?
Both?
Both.
Okay, all right, okay.
Working for our firm.
Okay, that's completed it, signed it, and sealed it. Get what they're saying there. I thought they had light finished it, or there was not a seal or something.
Let's cover that.
Well, the way it works now is, say a surveyor or engineer retires and they've done survey or set of drawings, and they're no longer there. They're gone totally. The engineer or surveyor of record is allowed to sign those on behalf of but that's something that there's no change in it whatsoever. You know, that's, say you need a piece of something. But here, what bothered me was if, say, a job is 90% completed, and then out of convenience, somebody wants to pull off that job and just give it to somebody else, is that okay? That's what bothered me, and I don't know that we're going to resolve this today. It seems like I would like for us to maybe put this, now that it's been introduced, maybe we can have a person or two that wants to take a stab at some tweak, eliminates, et cetera, or, add in some provisions that say what this was intended. I think it had a good purpose, but just like everything has a good purpose, sometimes it'll come back around and surprise you, but that maybe a person or two can take it and look at it and come back to us with some proposed language on it next meeting.
Demonstrated by my premature response to his hypothetical situation without understanding the facts, there's always a disadvantage. As a matter of fact, not many advantages of having a lawyer in the room. But I guess one here might be, I might be the person who can take that on and give it a try, and I'll be happy to try that. And I'll probably call you and get your thoughts on it a little bit more, and maybe some other folks from the engineering and the surveying side of things, but maybe I could look at it from,
Kent, I would appreciate that. Anyone willing to work with Kent on that? Okay, Tim.
I'd be happy to work with Ken as well. Kent and I can get together in Charleston somewhere.
very good, very good.
That's perfect. I do appreciate it, both of you, and I think you now understand, Kent, what the intent was. It was to, fix eliminate an undue hardship that was not created by the person that it was creating hardship for.
I think your concern is the legitimate concern. His is the legitimate concern from the other side of the fence. And so everybody has a concern, and the question is, how do you solve them as best you can, and we'll give that a try.
Good.
But our best interest has to be in the public, and in serving the public and making sure that the health safety is preserved, regardless of cost on one side or the other. That if it's the owner, obviously they're going to be upset because they paid for 90%, and what's going to happen to the other 10%? On the individual or the firm, when you talk about contract termination, it's not always just the individual or the licensee. It could be the firm that has been removed from the project, and therefore the owner paid 90%. That happens, and contracts get terminated. And again, we can't get caught up in any part of the cost. It is what it is. It's still the responsibility. The successor firm, depending on what percent of the project is done, if they decide to take over, it's their responsibility, and there's a cost associated with it. If they can't negotiate it, they can always walk away and not do it. So again, I don't think we can't get wrapped up around cost issues. It's everything about the interest we preserve for the public.
True, but we also have to be realistic about some issues. If a surveyor, in Henry's example, had done 100% or 99%, and he was getting ready to sign the plat the next day and had a heart attack the night before, do you have to back out and redo everything? So.
The key will be sure that some responsible person is responsible.
Exactly.
But do the best.
Exactly. So I think it's protecting health, safety, and welfare if we also look out for the money that's been spent by the public. So, I think we're all in agreement that we just need to look at it and see if we can improve it in some way. Thanks. Okay, I see our court reporter is here, so this time we'll go back to item 10, an application hearing, Philip Painter.
Page 27.
Okay, this hearing is called to order. This is the matter of Philip Painter. The purpose of this hearing is to determine whether Mr. Painter should be issued a professional engineering license. Everyone is reminded that these proceedings are being recorded and that all witnesses must be sworn before they testify. All remarks should be directed to the chair and all responses should be verbal. My name is Gene Dinkins, and I am chair of the South Carolina State Board of Registration for Professional Engineers and Surveyors. The attorney assigned to advise us during the hearing today is Eli Grote, Office of Advice Counsel with LLR. Other members of the board are Peter Strube, Angela Musselwhite, Kent Stair, Tim Rickborn, Jimmy Chow, Matt Kelly, and Henry Dingle. Does any member of the board have reason to be recused from this hearing? Hearing none, we will proceed. This hearing will be conducted in accordance with the provisions of the South Carolina Administrative Procedures Act and the board's statutes and regulations. Is the complete application package in our materials?
Yes.
What questions did staff have concerning this application?
Mr. Chairman and other board members, Mr. Painter applied for professional engineer licensure by examination on October 29, 2025. He bachelor's degree in engineering science from Coastal Carolina University in May 2025. He passed the FE and early PE exam. The NCEES record indicates 5 months of engineering experience after the accredited degree. His application was reviewed by a professional member and was not approved, citing the applicant fails to meet the experience requirement. Because of this issue, this application is before you today. Relevant statute includes South Carolina Code Section 40-22-220C1B, which states in part, the minimum evidence satisfactory to the board that an applicant is qualified for licensure as a professional engineer includes a specific record after graduation of 4 or more years of progressive experience in engineering work supervised by a licensed engineer and of a character satisfactory to the board and indicating that the applicant is competent to practice engineering. Regulation 49-200B 1A, which states an applicant must have completed the qualifying experience required by the board by the application deadline. Experience cannot be anticipated. Experience gained prior to completion of the qualifying degree requirements will not be accepted as qualifying experience.
Did staff subpoena anyone to be here today to answer questions we might have?
No, sir.
Is the applicant present?
Yes, sir.
Are you represented by counsel? Counselor, would you give us your full name and address for the record?
Arrigo, Arrigo, Karate, Carotti. I live at 1874 Bellamy Road in Conway.
Mr. Painter, do you have witnesses that you intend to call to testify on your behalf?
Counsel, if, Mr. Chairman and the board, I have some introductory remarks to make. There is no witness to be called and sworn in to testify. We do have a packet of materials, though, in the email that notifying him of the scheduling of this hearing. He was advised that if he had any materials to present to the board, bring them to the hearing, and he has actually done that. And that will assist the board in making a determination because it will complete the record. We have those here, copies made, that we'd like to hand up at this time.
We will get to that in just a minute. At this time, all persons who will testify should stand and state your name for the record. Mr. Painter.
Philip Painter. Oh, I'm sorry. I don't do this very often. Payntner.
Court reporter, can you swear him in, please? Mr. Painter, are you ready to show us why you should be issued a professional engineer license despite the questions raised? This time, you and your attorney may proceed.
Good morning. Thank you so much for taking the time to hear this case. The materials that we are going to provide the board include the following, and you can let us know when you want us to hand you.
Go ahead and hand them out now.
Just redacting some personal identifying information.
We would like to hand these back when we're finished, please.
Here, I'm prepared to proceed whenever you tell me, Mr. Chairman. In the materials, you'll find Philip's position paper, brief or case summary, whatever the case may be, that he prepared himself. I tell you, I thought it was quite impressive. Two, it's an affidavit from Dr. Brian Bunting. He is a member of the Physics and Engineering Science faculty at Coastal Carolina University in support of Philip's position. 3, transcripts showing undergraduate work being relied upon by Philip and then some. And 4, relevant portions of EAC/ABET, that's ABET for the benefit of the court reporter, accreditation criteria. As has been mentioned, just some background, Philip received a Bachelor of Science in Applied Mathematics from Coastal in December of 2016. From shortly after graduation, from January of 2017 until present, he has worked steadily at engineering firms. With the encouragement of some of his mentors, he went back to Coastal to get his engineering degree. He completed engineering technology coursework in 2022 through the fall of 2023 and obtained his Bachelor of Science in Engineering Science in May of 2025. Becoming a professional engineer has been a passion of his, a calling, although it actually took working in engineering and with other engineers to realize it. As soon as he was able, he took and passed all required examinations and applied for licensing in South Carolina as well as North Carolina and Georgia. He is currently working towards a Master's of Engineering. This case is pretty straightforward. The key issue and the only issue in this case is the beginning date for calculation of the 4-year post-education experience requirement for South Carolina licensure. That is, when did he satisfy the educational requirements, the qualifying degree requirements, so from that point forward, his experience could be counted. Applying for the South Carolina engineering license in October of last year, it was determined that he had only received 5 months of eligible engineering experience. That is, it was calculated from when he received his Bachelor of Science of Engineering Science in May of 2025 through October of 2025, last year, 5 months. The statute that was relied on was Section 40-22-220C1 and Regulation 49-200B1A. However, as you know, there is an alternative education requirement, alternative to the one found in subsection C1, which states graduation in an EAC/ABET accredited engineering curriculum, and that is the one found in 40-22-220C2, which says graduation in a bachelor's degree program and completion of an engineering curriculum found to be substantially equivalent to an engineering curriculum accredited by EAC/ABET. And it is by 40-22-220C2 that Philip will demonstrate to the board that he satisfied the educational requirements for licensure by the end of the 2023 fall semester. That is by December of 2023. And that calculation of his 4-year post-education experience requirement should begin at that time. not when he received his Bachelor of Science in Engineering Science in May of 2025, almost a year and a half later. He asked the board to accept his coursework through the fall of 2023 as EAC/ABET equivalent education, equivalent to an engineering curriculum, satisfying the completion of qualifying degree requirements, and establishing December of 2023 as the start date of his 4-year post-education experience requirement for South Carolina licensure. And I'll turn it over to Philip because he can answer any technical questions, having that knowledge far beyond my own for the board. I just have some very small closing remarks once you all have had engineer speak between you.
When I initially sent the request, I wanted to argue a case to see if I could get some of my time essentially counted back. I've been working for about 9 years now, so my intention, obviously I don't want to break any rules or regulations in the South Code, but just within the workings of the rules and regulations, to get time, and move the date. So I'm not leaving today with the license. I just wanted to see if I can get a little bit of my time back.
That conclude your presentation?
Beyond what's in the packets,
You'll see it more explicitly set forth in the materials that the board has been provided with.
But would you like to give us a synopsis in your presentation? The floor is yours if you want to guide us through this. If not, we'll take a look and ask questions.
apologies,
Yeah, you're not getting picked up on the microphone there.
I guess I suppose it's a good thing I'm not in court hearings very often, but I looked at ABET's engineering requirements, which I have put in there. Being that I have an engineering science degree, there's a loose paper at the end of the ABET packet that essentially just says that engineering science has no program-specific criteria beyond the general criteria of an engineering program set by ABET. So I don't have any requirements besides what are set forth in the general requirements of the So criterion 5, which is the curriculum, a minimum of 30 semester credit hours of a combination of college-level mathematics, basic sciences, with experimental experience appropriate to the program. Being that I have a bachelor's in applied mathematics degree, I'm more than willing to go over the coursework with you, but I've taken math all the way from college algebra to differential equations, as well as partial differential equations, differential geometry. It is laid out, though, in section 4 of my synopsis here, all the math that I've taken, Calc 1, 2, 3, differential equations, linear algebra, advanced calculus 1 and 2, complex analysis, differential geometry, a MATLAB class, which should cover the math requirements for ABET Section B says a minimum of 45 semester credit hours or equivalent of engineering topics appropriate to the program consisting of engineering and computer sciences. So next section 5. Including the coursework that I took at Ori Georgetown and the coursework that I've done at Coastal. I believe ABET also has a requirement, though I could not find it, that one of those classes has to be a senior design class or some form of design class, which is supplemented by Engineering 399. Integrated Science and Engineering Design. So the coursework is Engineering Statics, Engineering Mechanics 2, which is Dynamics, Strength of Materials, Engineering Materials, Thermodynamics and Heat Transfer. It is listed as a physics course because when I originally was at Coastal, the engineering science program does not exist, but I have taken fluid mechanics, if the board would be willing to that as an engineering course. Environmental systems, intro to civil engineering, intro to engineering, drainage design, building construction and plan reading, integrated science and design, which is my senior design course as required by ABET. My cornerstone design course, engineering internship, and that should total up to the 45 credits required for the 3 semesters of engineering courses. Section C, a broad education component that complements the technical content of the curriculum is consistent with the program educational objectives. I already had a bachelor's degree, so I believe that is covered within the bachelor degree I'd earned at that point. And accumulating major engineering design experience incorporates appropriate engineering standards and multiple constraints is based on the knowledge and skills acquired in earlier coursework. I believe that is the section that is the senior design and cornerstone design course. Or that would include those courses. The second sheet that you were all given, we brought this argument up to a professor of mine. His name is Dr. Brian Bunton. He was one of the faculty that was responsible for Coastal's engineering program actually becoming ABET accredited. And we ran our case by him, and he signed the affidavit essentially agreeing with the case that I am presenting. The third packet is just my transcripts. It has everything from undergrad all the way to my first semester of my master's degree included.
Okay, thank you for your presentation. Board members, any questions of Mr. Painter?
So, Mr. Chairman, let me figure out the purpose. The introductory statement was that the purpose of this hearing is to determine whether Mr. Painter's professional engineering license, but did I understand you that's not the purpose that you're here for?
It's to set the date of completion of the statutory educational requirements so that any experience that occurred thereafter would be counted towards his 4 years of post-education experience requirement for South Carolina licensure. He submitted an application to this board, apparently, and it was determined because, quite frankly, the reviewer didn't have all the information that you do now. It was determined that the start date would be when he received his Bachelor of Science, a Bachelor of Engineering Science in May of 2025. But he completed all the coursework necessary under ABET back at the end of the fall semester of 2023, which means the start date, and we're asking the board to determine that the start date for the beginning of consideration of his 4-year experience, 4 years required experience, is December of 2023, not May of 2025. And that's a year and a half's worth that he has experience that should legally be considered as applicable towards the 4 years. And you'll see that Dr. Brian Bunton, who's very familiar with this, being a professor of both physics and the engineering science program at Coastal, and he actually participated in that accreditation, ABET accreditation. He says that his coursework, by the end of the fall semester of 2023, it's paragraph 7 of his affidavit, last one, actually exceeds ABET criteria and demonstrates completion of an engineering curriculum substantially equivalent to an engineering curriculum accredited by EAC/ABET, which is the statutory requirement under 40-22-220C2. So we're asking the board to set the date of his education qualification to start the 4-year clock back in December of 2023, as opposed to what the reviewer of his application for South Carolina licensure found to begin it in May of 2025, but he didn't have the information that you have.
So Mr. Painter originally applied for a license, correct?
October of last year.
Okay, and that was denied for the reasons you've just stated. What you're now doing is you're not contesting the denial of the license, you're just asking for an advisory ruling as to when his time starts?
Essentially, yes, sir.
Oh, well, since you're a lawyer and I've played one, precedent for asking for an advisory ruling from the board as to when somebody's time starts, or should they not just wait until they think that this applies and then do it?
That's actually an excellent question, and it's a legal question, and it brings in the doctrine of ripeness. Mr. Grote could give you advice on that. This case is ripe because there is a decision based on facts that are established. It's not something that is going to change within the next year and a half or 2 years. It's not going to change. The decision that was made, the determination that was made by the board is that he had only received 5 months of experience post satisfying his education requirements. We're saying, no, he should receive credit all the way starting back December of 2023. If you call that an advisory opinion, I believe this board, like several state agencies, has the legal authority to issue one. It's not like the federal court system, case or controversy under Article 3 of the U.S. Constitution. There are state agencies that issue advisory opinions all the time. For instance, the FDA, Department, HHS, the State Ethics Commission, the Attorney General's Office. State agencies have that ability if you want to categorize this as an advisory opinion. But I think issuing an order or amending the order that was issued denying, which contained as part of its factual findings the number of months that would be considered eligible for experience post-education requirement satisfaction, be amended from 5 months to however many months in a year dating back if the start date was December of 2023.
On the issue of ripeness, I mean, it strikes me that ripeness will occur in December of 27 after he's been out of whatever his undergraduate or the first degree was. Then he would be ripe for the question, is this 4 years good, or must I wait from 4 years until 2025? Seems like this is not quite ripe yet.
I would submit that legally, it is ripe, because this does not require further factual development, and there would be hardship to the applicant not deciding this issue now to his benefit if he's required to wait 2 years to raise this issue again. We're going to have to be back here again, and there's no predictability. He's employed. His employer would like to know what his timeline is for licensure. I mean, that's going to affect his job and his employment and his future, having to wait 2 years of uncertainty when this board has already made a determination that they could amend and clarify that for both Mr. Painter and his employer. So it satisfies all the tests for this being judiciable, that this is ripe for determination by this board, because it's something that has already occurred in the past. Nothing's going to change in that regard between now and 2 years. Ripeness is if there are uncertainties, there's speculation about what the future holds, and it's premature to issue a decision. There's none of that here. The facts are already established based upon what the request is. In addition, it would create a hardship not to decide that issue now with respect to Mr. Painter and his employment with G3, because they're wanting to know when he's going to be eligible, when this board's going to decide he's going to be eligible for South Carolina licensure, to plan his employment and future there. Satisfies all the legal requirements to allow legally this board to address the issue and decide upon it.
If we started doing this, would we not find ourselves in everybody coming in and saying, here's my situation, and is this going to be enough if I keep doing it? The lawyer doesn't want me to stay along if whatever I'm doing is not enough. I mean, don't we just have situation after situation come up?
Well, the only thing that happened here is perhaps all this material that you were given today should have been included in his application, and the board would have made that decision already.
Still would have denied it because he hadn't met the 4 years from 2023.
But would have made a factual determination, as they have already, that his experience, as opposed to beginning to be eligible in May of 2025, would have begun in December of 2023. That would have been a decision that the board would have made already, and we're just asking for that amendment to be made.
One final question, is 4022 2020C. I don't have it in front of me.
But I do.
Okay.
Hand it up.
I'd like to see it, just I don't know if it's.
Mr. Painter, were you issued a degree in December 2023?
No, I already had a bachelor's degree in applied mathematics from 2016, so.
So when did you get, and what degrees, at what time frame?
Initially, my first degree was an applied mathematics degree with a concentration in physics in 2016, or December of 2016, to be more specific. Once Coastal got their ABET accreditation, I went back, and in 2025, I earned my engineering science degree.
2025. So in 2016, was that a bachelor's degree or associate's?
That was bachelor's of science.
Bachelor in applied mathematics. In what degree in 2025?
Engineering science. A bachelor's, sorry.
So you're asking us to say, after 2016, you took additional coursework, and this board should review all of those individual courses and say it's equivalent as of a certain date. You're asking us basically to become the ABET reviewer and say it's
Yes, sir.
If I may, and you will correct me if I'm wrong, I understand that the general practice of the board would be to send this to a consultant for review. I don't know if you do that or not, but Mr. Painter would be happy to work with that individual to verify that his coursework is substantially equivalent to EAC/ABET requirements. In fact, Dr. Bunton also mentioned that Philip could even obtain and provide syllabi if needed. You'll see in his, Dr. Bunton's affidavit that what Philip was pursuing after he decided to get a second degree, a Bachelor of Science, he began at Georgetown Technical College as part of a bridge program between Georgetown Technical College and Coastal Carolina University in furtherance of obtaining his Bachelor of Science in engineering science, together with all his coursework he took for applied mathematics for that degree. In addition to the work that he did at Coastal Carolina, at Georgetown Technical College, which was engineering related. By fall of 2023, he had enough coursework to more than exceed ABET accreditation criteria. And that's what the statute says is sufficient.
This board does not review individual courses and determine, what they apply to, what they're accredited for. That's above and beyond what this board should do. You have educational consultants. But are you suggesting then, and I know Mr. Painter you do have a degree in 26. Are you suggesting, say, if someone didn't have any degree and they came in with a smorgasbord of this course, this course, this course, this course, this course, board, take a look at these, all these together would be the same as a degree?
That's not what the statute allows. The statute requires that he has to have graduation in a bachelor's degree program and completion of an engineering curriculum found to be substantially equivalent to an engineering curriculum accredited /ABET. So under your scenario, that person would not satisfy the educational requirements of the statute.
That engineering curriculum that Mr. Painter obtained was obtained in May of 2025. That degree.
It was obtained by the fall of 2023. Is substantially equivalent to an engineering curriculum. The courses that he took for applied mathematics, the courses that he took at Georgetown Tech, and those were what kind of courses, Philip?
The courses that he took, but not the degree that was obtained.
Correct, and that's not the requirement. That would elevate form over substance, and that's not what the legislature had intended.
Painter, do you know whether Georgetown Technical College, whether they have any sort of ABET accreditation for their engineering program that's there?
They Don't believe so, but there are several colleges that do bridge those courses over. I know Clemson University is one, and if this does get sent to someone to evaluate that, I would be more than willing to obtain like those transfer equivalencies and the equivalencies to Coastal Carolina University.
Bridge program is exactly that. It becomes part and parcel of Coastal's accreditation. They accept the courses with that understanding. So the courses that are taken at or Georgetown Tech are acceptable to Coastal in the pursuit of a Bachelor of Science, of Engineering Science that is fully accredited under ABET. Comes part and parcel as part of a bridge program. That's in Dr. Bunton's affidavit as well.
You know how many of the hours and which courses they accepted? Because it appears to me you earned 100 hours at Horry Georgetown Tech, but according to the Coastal Carolina transcript, 25. Transfer. I'm sorry. Total institution was 28 at Horry Georgetown. I guess the 72 was your Carolina with your math.
Yes, I think they took, when I went to there, they required my Coastal transcript.
So again, we don't know which of the, out of the 28, which of the 25 they accepted.
I believe, and Coastal Carolina University got rid of their Intro to Engineering course, so transfer.
So I can get my dates. I heard there was a degree in 2016. That one's not in play. Is that correct?
That is correct.
Okay, so we're looking at degrees in 2023 and in 2025. Those are the two degrees that we're looking at? Or,
No, so the 2016 degree is in play
Okay.
as satisfying a portion of C2 and the courses that he took to earn that degree. He did not earn a degree in December of 2023. He had taken sufficient engineering coursework, substantially equivalent to ABET accredited coursework, to satisfy the education requirements. And that was part of his work that he undertook to ultimately earn his Bachelor of Science in Engineering Science from Coastal in May of 2025. So yes, the 2016 degree under the statute requirement is in play, in addition to coursework that he took to earn that degree. He did not earn a degree in the fall of 2023. He was
Right.
matriculating.
okay, my terminology in play was a little loose. So, but we're looking, we know we've got to have 4 years of experience, correct? And the real question here is, when does that 4 years begin? And it's either begins in 2023 under your argument or 2025. But either way, 4 years hadn't occurred since either of those dates. And to be given a license, you have to have both the education or the equivalent education plus 4 years. And what you're saying is you've got the equivalent education and you want the board to make that determination, but you don't have the 4 years, and so we're not really ready to do anything on the licensing anyway. And so I guess my question for ripeness, it seems that instead of asking the board to have somebody academically determine whether academically you've met your equivalency. When you haven't met your 4 years, that could be a very academic effort on our part, because next year he may decide he wants to be a doctor or something like that. And so we have then spent a lot of time and effort determining an educational background that never really is ripe because he didn't do the 4 years of experience. And that's the ripeness question I've got. I mean, it seems that the appropriate time would be to come back in 2027 and say, here's my equivalency, and you all need to study it to the extent you need to study it, and here's my experience, and we'd like to be, granted a license. But to determine half of that before the 2027 gets here, when the other half may not ever occur, just seems like it's just kind of hamsters run around the wheels too much.
And that's the board's prerogative, but that leaves an outstanding order and a factual finding by this board, which we say is incorrect.
Seems that I don't know what the ruling of the board has thus far been, but it seems that it is nothing more than he has not completed his requirements for a license. And I think even under your arguments, you'd acknowledge he's not completed the requirements for a license. And so it seems like the only precedent here is that as of the moment his application was reviewed, and as of this moment today, he's not completed the requirements under anyone's arguments. So it just seems like we would all be better served by waiting until there is an argument, and you can sit there and say, here is the reasons it's equivalent, and you need to get your education person to look at it, and here's the reasons for his experience, and they're valid. And I mean, I understand he would like to know, but it just seems that if we do this, we're going to be sitting here with everybody who'd like to know something about some future thing that may never happen.
And then his employer and Mr. Painter is left with the understanding, based on the board's already finding, that it's going to be long after the end of next year before he's eligible for licensure in the state of South Carolina, because the board's already made a finding that through October of last year, he only had 5 months of experience, so he needs an additional 3 years and 7 months to satisfy the experience requirement. And we say he doesn't need an additional 3 years and 7 months. He only needs to the end of next year.
I think I understand your argument.
And for what it's worth, if we do need to come back, we will come back. I don't know if this helps my case or not, but I am a licensed engineer in North Carolina and Georgia. I'm not going anywhere. So if this needs to be taken up at a later date, I'll be here. So I will, obviously I appreciate the board's time and even taking the time to review this and listen to me. And if, it is in the board's opinion that this needs to wait until I have met the standards to be licensed in South Carolina. I was born in the state, raised in the state, and I have no intention of, breaking the rules or, stepping on anybody's toes. So I just appreciate everybody's time. And, if, the ruling is, we should wait, I'll be here.
There's not a thing you've said that I take issue with, and I accept. I think you're quite sincere, and I would imagine that you will be back, and you're not going to be a doctor in 4 years. So, okay, good. Thank you for your candor, and thank you for coming here.
And thank you, everyone.
Mr. Chairman, one question. Did you state that you're enrolled or planning to enroll in a master's program in engineering?
I am enrolled. I've only done my first semester, so there's just one page at the end of my transcripts from the University of Oklahoma. I took water resource systems modeling and hydrometeorology this fall, and I will be taking some more courses in geographic information systems and some project management courses next semester.
When do you plan to complete your master's?
I will be done in the spring of '27. And then my plan is to actually get my associates in surveying. I've actually passed the FS exam about the same time that I passed the FE exam. I'm short, I think, 6 credits educationally because I obviously with an engineering science degree, I don't have any surveying credits on that degree. So my plan is to go back and eventually take my PS exam and get that license as well.
Thank you.
I don't want to discourage you from going to med school. You strike me as someone who would be a very good doctor. But I wish some of mine had your good attitude. Thank you.
Sir.
Any further questions from the board? Mr. Painter, is there any additional relevant evidence that you'd like for us to consider?
No, sir.
Okay, your case is submitted and the board will take it under advisement. Is there a motion to go into executive session to seek legal advice?
So moved.
We have a motion and a second. All those in favor, say aye.
Aye.
Opposed? Will everyone please be excused while the board goes into executive session? Out of executive session. Is there a motion as to the disposition of this?
Yes, Mr. Chairman. I'd like to make a motion to initially and to deny the applicant's application of licensure as submitted. And furthermore, due to his unique educational pathway, to allow the applicant to submit his educational curriculum to our educational consultant to determine if such curriculum is found to be substantially equivalent to an engineering curriculum accredited by EAC ABET, and if so, to establish such date of the equivalency.
For a second. Second. Motion and a second.
Aye.
Opposed? Ayes have it. The decision expresses only the basic elements of our ruling in this case. Council will prepare a document that more fully expresses our order as traditionally used and will be the final order. Written final order will be approved and signed by the law court within 30 days of receipt.
Thank you.
Is the next one on video?
Let us know when you're ready.
Okay, let me just. Dr. Sassani, can you hear me? Oh, wait a minute. Dr. Sassani, can you hear me?
Yes, I can.
And can you see us on the screen, the board there?
Yes, I can.
Okay, I think they're ready to begin. You ready to go?
Yes, I am. Thank you.
Okay, Mr. Chairman, the parties are ready to proceed.
Mr. Elliott. Thank you, Mr. Elliott. This hearing is called to order. This is a final order hearing in the matter of Concrete Structure Failure, LLC, case number 2025-89. This is also a hearing in the matter of Meridad Sassani, license number ELS 44165, case number 2025-24, pertaining to Dr. Sassani's request for the board to reconsider or alter or amend the board's prior order issued in case number 2025-24. My name is Gene Dinkins, and I am chair of the South Carolina State Board of Registration for Professional Engineers and Surveyors. The attorney assigned to advise us during the hearing is Eli Grote, Office of Advice Counsel with LLR. Other members of the board are Peter Strube, Angela Musselwhite, Kent Stair, Tim Rickborn, Jimmy Chow, Matt Kelly, and Henry Dingle. Everyone is reminded that these proceedings are being recorded and that all witnesses must be sworn before they testify. All remarks should be directed to the chair and all responses should be verbal. Does any member of the board have reason to be recused from this hearing?
Yes, Mr. Chair, I previously recused myself in this matter.
Thank you. So Mr. Rickborn is recused. Any other members? Hearing none, we will proceed. This hearing will be conducted in accordance with the South Carolina Administrative Procedures Act and the board's statutes and regulations. The state is represented by Christopher Elliott, Assistant Disciplinary Counsel. Is Respondent Meredad Sassani present?
Yes.
Are you represented by counsel?
No.
Do you understand that you have the right to be represented by an attorney?
Yes.
Are you waiving your right to have an attorney represent you today?
Yes, I am.
Is a representative of Respondent Concrete Structure Failure LLC present?
Yes.
Please state your name and your position with Concrete Structure Failure LLC.
Meredad Sassani, Chair.
Is Concrete Structure Failure represented by counsel?
No, it's not.
Are you an officer or employee of the company?
Yes.
Has a written authorization been signed by the president, chairperson, general partner, or chief executive officer of Concrete Structure Failure LLC authorizing you to represent the business here today?
Yes.
I'm sorry. Yes, it has. Sorry, Mr. Chairman. I didn't mean to butt in. This being currently marked as State's Exhibit 1, and I'm going to hand you a copy as well. Also being marked as State's Exhibit 2, Concrete Structure is waiving. We put this together last week, maybe before last week. Concrete Structure is waiving its right to 30 days notice of a hearing, as is required under the APA, in order to have the matters heard quickly. And at the same time, the company has waived its right to 30-day notice and is appearing on shorter notice. I'm providing State's Exhibits 1 and 2 to the board chair and his counsel for review.
It is my understanding that the parties have entered into a memorandum of agreement and stipulation of facts in the matter of Concrete Structure Failure LLC, case number 2025-89. Is that correct?
Yes, Mr. Chairman, the parties have entered into a memorandum of agreement and stipulation of fact, which is provided in the board's materials. I'm putting a hard copy into evidence as State's Exhibit 3. I am also putting into evidence the exhibit, and this is also in your materials, the materials that were provided to the board at the last motion to reconsider hearing in November. Nothing has changed with regard to the documentation associated with that motion, but to bootstrap the record, I'm putting all the materials that you have a copy of that were introduced at the previous motion to reconsider, just entering them into the record for this hearing as State's Exhibit 4.
Dr. Sassani, do you have any objection to any of those 4 exhibits being admitted into evidence?
No, I do not.
The exhibits are admitted as evidence. Dr. Sassani, you can now address the board and present any mitigating testimony or evidence that you might have.
I'm sorry, it's regarding what which
Okay,
one?
wait.
Hang on a second, Dr. Sassani.
Before you do that, Mr. Elliott, would you present the MOA and stipulation of facts to the board?
We get to that. As far as the motion for reconsideration, do we have notice of that, or is Dr. Sassani agreeing to appear today and waive any notice of that?
Dr. Sassani, are you comfortable? I did not formally notice you for the motion to reconsider. In order that we can have both of these hearings today at the same time, are you waiving your right to formal notice of the motion to reconsider hearing?
Yes, I do.
Okay. Mr. Chairman, with regard to the two matters that are, of course, related for the board's consideration today, I think everyone was here last time in November when we had the motion to reconsider of Dr. Sassani's order in case 2025-24. This was a final order issued by the board in August of last year, wherein Dr. Sassani personally was publicly reprimanded and fined $500 for unlicensed work prior to submitting an application to the board for licensure. At the conclusion, there was a good bit of, Dr. Sassani gave a good bit of testimony. There was a good bit of documentation. And at the conclusion of that hearing, the board deferred ruling on the issue or on the matter until such time that it could be heard in conjunction with the related matter 2025-89, the matter of Concrete Structure Failure, LLC. At the time of the first hearing with Dr. Sassani, it was not known to the state or the board, it was not brought up at the hearing, that there was such an animal as Concrete Structure Failure, LLC, which was the company that Dr. Sassani operated through for the projects in question. Dr. Sassani came before the board on his motion to reconsider basically with an ask. He was asking, based on his failure to present his case well, again, he's operating, practicing law in a second language, that he was asking for the board's leniency in that could the board sanction and publicly reprimand and fine the entity, Concrete Structure Failure, LLC, which was the business he was operating through, instead of himself. Again, the board, at the time of the motion to reconsider, deliberated and decided that it didn't want to decide the matter without having both matters in front of it. And now it does. The Concrete Structure Failure, LLC Memorandum of Agreement is in your materials. It's State Exhibit 3. And in it, the company itself, which is waiting for licensure and cannot, of course, be granted a COA from the board until this disciplinary matter is resolved, the company is admitting to unlicensed work. The company understands that it is very likely to be sanctioned by this board for this unlicensed work. Dr. Sassani could certainly, I think we've explained it a good bit, but he's certainly here to answer any questions about the work itself. The state has no recommendations or desires in these cases. All I can say is Dr. Sassani's been very easy to work with. He greatly appreciates the board. He's coming to us from Boston today, and he has reiterated to me numerous times how grateful he is to the board that they allow him to appear remotely. He just finished teaching a class at the university where he teaches, and he's certainly very grateful that y'all allow him to appear remotely for these hearings. Mr. Chairman, that's really all I have. I don't think any of this is rocket science. If it was, I wouldn't be allowed to do it. So I think the only question is what the board would like to do with these matters. Mr. Chairman, unless the board has any questions for me, I would yield to Dr. Sassani and whatever questions y'all have for him.
Okay. At this time, we will hear from Dr. Sassani, but before we do that, Dr. Sassani, I'd like for you to be sworn in before you testify.
Raise your right hand. Solemnly swear or affirm that the testimony you will give in this matter today will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you.
Dr. Sassani, you may now proceed with any presentation that you have.
I don't have any new presentation. I just want to re-emphasize that what was read to you is actually my view, and I just want to renew my request.
Everybody hear that? Can you repeat that, please? We're having a little audio difficulty.
Okay. I mentioned that I don't have anything new to add beyond what we discussed last time. I just want to renew my request to consider what I had submitted before.
Any questions of Dr. Sassani?
Okay, Mr. Chair. May I ask one question either of Mr. Elliott or Dr. Sassani, just for clarification of the MOA for Concrete Structure Failure LLC? Paragraph 3, it refers to it being a reinstatement application. Was it a reinstatement application or an application for a new COA?
Let me defer to Ms. Miles on that one. I believe it's just an application.
Yes, it is an application.
Inartful drafting, Mr. Grote. I apologize.
Okay. Is there anything further from the state or from Dr. Sassani in this matter?
No, Mr. Chairman.
No, thank you.
Is there a motion to go into executive session to seek legal advice? We have a motion and a second. All in favor indicate with an aye. Aye. Opposed? We're in executive session. Would everyone please be excused? Yes, let's take a 5-minute break.
I would just caution everybody, nobody should speak to Mr. Elliott.
Dr. Sassani, can you hear me?
Yes, I can.
Okay. And you can see us?
Yes, I can. Thank you.
Thank you.
Okay, Dr. Sassani, we just came out of executive session. Is there a motion as to the disposition of these matters?
Yes, Mr. Chairman. I'd like to make a motion regarding case 2025-89 regarding Concrete Structural Failure LLC to accept the memorandum of agreement and issue a public reprimand and a $500 fine. Furthermore, regarding case number 2025-24 associated with Dr. Sassani, that we move that the prior board's action be vacated and Mr. Sassani be issued a non-disciplinary letter of caution.
We have a motion. Do we have a second?
Second.
Have a motion and a second on the floor. All in favor indicate with an aye.
Aye.
Opposed? The ayes have it. The decision we announced today expresses only the basic elements of our rulings in these cases. Counsel for the board will prepare documents which more fully express our conclusions in the appropriate language and format which the board has traditionally used. The written final orders will be approved and signed by the chair. If the respondent in either case wishes to appeal the respective order to the administrative law court, the respondent will need to do so within 30 days from receipt of this order. This concludes the hearing.
Thank you, Mr. Chairman.
Thank you very much.
Okay, getting near the end, item 15, public comments. Any comments from the public?
He went home.
He left. Comments? Lloyd, thanks for coming. That concludes the items that we have on our agenda. One thing that has been brought to my attention, and Lenore, I want to mention this to you. Can you go back and possibly get us a list of past board members and bring it to us over the last few years since we last elected and for them emeritus members? Been some time since.
If my memory serves me right, I think Johnny Johnson was the last.
Okay. I don't remember, but they don't become emeritus members unless this board votes for them to, and then they're submitted to. Couldn't be that many, but if you could get them, and we'll take those names up, and let's put that on the agenda for the next meeting to vote on any or all of them to be emeritus members. Anything further?
One other thing, I don't know if it should be on or off the regular. Last meeting, we discussed.
Not getting picked up there.
Last meeting, we had some preliminary discussion about the educational credit that you guys ought to get for being at these meetings, and I was of the opinion, and very strongly so, with health, education, and welfare on a moment-by-moment basis. And I think that you all should get if you can help understand the issue and the credit better, I will take it upon myself to make a motion formally in whatever fashion, because I've seen y'all work, and it's that. Talk with you about that so you can get some more information on it.
Thank you. I think that's just a comment for us to consider. No action needed, but we can talk about it. Anything further? If not, is there a motion to adjourn?
Second.
All in favor?
Aye.
Aye.